Hello, I'm Von D. Kirby, investment immigration attorney based here in San Francisco. I delayed doing this video for some time because I wanted to have some meaningful information to present to you, and that's even difficult at this point, but I wanted to discuss retrogression. EB-5 is difficult enough. You're being asked to make a large investment which will impact, obviously, economically, but also the future of your family. And retrogression is asking you essentially to get in line without a full understanding of where you are in that line. So let me try to discuss some of the news and some of the information you'll receive, and let's see if we can make sense of it. Excuse my notes, but I wanted to make certain that I had accurate numbers for you today. Number one, we know that in May 2019, Mr. Oppenheim predicted that retrogression for people from India would be 8.4 years. This was based on data that he used to make this prediction, and that is very important to understand. His data was based on 2.4 to 2.6 derivative applicants per EB-5 application. Now that is important because that affects the number of people in line, which effectively affects your position in that line. We have had discussions with other professionals in this field and then based on our own experience, and we find that number to be much lower, perhaps closer to 1.5 to 1.6. The reason we have found that is that many of the applicants today tend to be in the United States with an approved I-140 for their EB-2 or EB-3. They've been here many years, and their children tend to be American citizens. So because of that, we find the number of derivative applicants per application much lower. Then we have the July 2019 Visa Bulletin. Now this Visa Bulletin said that those applications filed after May of 2017 would no longer be current. That means those applications essentially would be in retrogression. Now let me offer a quick definition here. You will hear current. That means that your particular priority date is available. Your priority date is the date that USCIS accepted your application, and that will be on your notice of action receipt that you'll receive a copy of from your attorney. So if your application was filed before 2017 in May, you are current and you'll be able to move forward. If it is filed after that, you will be subject to a delay. Now, with all that information, we have determined that we believe retrogression is very real under the current law, but we believe that the delay, the retrogression for your particular application, will be closer to 4 or 5 years from your priority date. Now, this is our estimation based on the information we have, which is limited. So you can't rely on this 100%, but it gives you a different indication than what Mr. Oppenheim said based on the figures that he used. Now with that 4 or 5 year retrogression, you're having to make a very difficult decision. If you're filing your application today, you need to decide whether it makes sense to you. And there are a lot of questions that have to be answered. You have your personal questions. Will a green card have the utility for my family if I have to wait 4 or 5 years? And you're going to have to answer that question for yourself before you invest. Does it make sense that I will have a green card in the future? Will that be of value to my family? The other factor which I like to point out is we do see a real trend in Congress to increase the investment amount, which means that if you invest today, you'll be investing under the law as it exists today. And we expect the number for the investment to increase by at least 60 to 100%. In other words, people that invest after the change in the law will be paying twice as much as you did for the same immigration benefit. I hope this information was helpful to you. I recommend you have a discussion with your investment immigration attorney. If you're my client, certainly feel free to discuss these factors with us. We'll do the best we can to make sense of a difficult situation. And we do have hope out there that Congress will address this question. Because when EB-5 was conceived and passed, there was no anticipation of the demand that we've experienced. So there is a very good chance that we'll see Congress address this issue. We can certainly hope, but you must make your decisions based on the law as it exists today, not as how we hope the law will be in the future. I hope this was helpful to you.